Well, let's look at what he did when he entered the country. He came to attend his uncle's funeral. So he entered for a legitimate reason, permitted as a visitor. He came as a visitor to attend his uncle's funeral. This is from the State Department, but it basically states that when you enter as a visitor, you're really ineligible to change your status to F1 unless you made your intentions plain at the outset. So when you enter the United States as a visitor, you're coming to your uncle's funeral. If the person said, well, I'm coming to my uncle's funeral, but while I'm here, my cousin's going to take me around and he's going to show me different schools in Mississippi, and I might decide to go to Meridian Community College. I'm going to look at Mississippi State, I'm going to look at Ole Miss, and I might enroll. Of course, at that time, what the officer can do is he can annotate his notes, because these officers now take very detailed notes with their entries. They're putting these into the system. And he can actually note that this fellow is entering the country with the purpose of possibly seeking to enroll in school. So, persons admitted under B non-immigrant visitor status will be able to change their status only if they stated their intent to study when they initially applied for admission and presented any I-20 forms that they may have been issued. They may have an I-20 or they may not. They may not have gotten that far. But it's much more tightly controlled now than it used to be. As far as I was able to research, there was no clear-cut pronouncement from the Immigration Service. And there may be something in y'all's NOFSA material, but in this fact situation, I was able to find no clear-cut indication from the Immigration Service as to whether this fellow was in fact had violated a 90-day rule. But in a listserv, and I talked to a number of other attorneys, the consensus was that he probably has shot himself in the foot by this point. If he's gone 90 days with post-completion OPT, even though he's registered for dissertation hours, he's probably violated the 90-day rule. Now, is he eligible at this point for a change of status to H-1B? Let's say his employer says, okay, well, we'll just file a petition for you and change you from F1 to H-1B. Is he going to be eligible for change of status? Probably not. Probably not, because keep in mind, to change from one non-immigrant status to another, you've got to be in good status to begin with. You've got to have a good foundation that you're moving from. Now, what you might consider, let's say that this fellow had a real concern about leaving the country and going to apply for a visa. Jaideep from India is probably going to be okay. But let's say he's Mohammed from Syria or from Egypt. He might have a real problem. He might have a real concern about departing the country and going and applying for a visa. At best, he could be looking at, he might immediately get a visa if the consulate's open, but likely he's looking at a 2, 3, 4 month delay in security check while he's applying for his visa. So let's assume that he's got a real concern about departing and applying for a visa. What I might try is a provision, I think it's section 248 in the Code of Federal Regulations, that pertains to changes of status. And it says first you must be in good status, but if you're not, you can at least invoke the discretion of the Immigration Service. If you are otherwise in good status, if you haven't violated your status otherwise, if you haven't been engaged in unlawful employment, and if you're not in deportation, and if the circumstances which caused this were beyond your control or not due to your fault, you can ask the Immigration Service to approve a change of status. It might be worth a try I would probably do it on premium processing, but this is probably a case where they would say that this was this fellow's fault, and more than likely he's going to have to depart and go back and get a visa. He could probably do it. What you do is you get your H-1B petition in place, you get your premium processing, get that petition approved, and let him go home and get his visa, maybe with a nice letter from the DSO that explains that Jaideep, got busy and didn't realize that he was violating the 90-day rule. Okay, here's the 90-day rule. Periods of unemployment during post-completion OPT. During post-completion OPT, F1 status is dependent upon employment. That pretty well says it right there. If you're holding an OPT card, post-completion, if you're not working, you're ticking off days of potential lapse of status, I guess would be one way to express it. Because if you're holding the card and you're not working, every day that goes by adds to that, amounts up to that 90 days. And the 90 days is 90 days within that 12-month period of OPT. So let's say let's say I'm unemployed 6 weeks or a month. I get a job and it lasts for 2 or 3 months, and then I lose my job, or the job plays out. Now my time starts to click again. It doesn't start over. It starts adding to that month or 6 weeks that I had at the beginning. So it's within that 12-month period.
Do they count weekends?
Yes, every
day.
Every calendar day that you're unemployed. Yes, that's a good question. They actually count the days you're not even in the country. So if you do happen to depart the country and come back in, unless you're employed, they add that to the 90 days.
There.
If you have an unexpired EAD, post-completion, otherwise admissible, you can return to resume your employment. It must be used in combination with an I-20 endorsed for reentry by the DSO within the last 6 months. And this is my comment. If the visa is expired, she'll need to apply for a visa at the consulate abroad, and she'll be resubjected to the scrutiny of Section 214B. That is, your intent to return to an unabandoned residence abroad. Generally, it's not advisable to depart the United States in OPT if the F1 student will have to apply for a visa to re-enter the country.